Okay, I'm done.
Thank you, Senator Cameron. Senator Day.
Ms Webster, you said in your evidence earlier that your office complied with your agency's litigation policy in pursuing the Quest case, and that all litigation should be constructive and proportionate. Is that right?
That's correct.
Yep. Given that the Fair Work Ombudsman was so comprehensively defeated in this case, and in particular the judge's findings of fact, not law, how is an appeal to the full bench constructive, proportionate and fair to these three contractors?
Well, Senator Day, just for the record, we weren't comprehensively defeated in the matter. There was an aspect of the case where we were successful. I think that's important to note. But the matter is under appeal, Senator, and I think that's it's important that we note that and that we don't go into the details of the matter.
Well, let's go to that constructive and proportionate. If launching an appeal and running $1 million court case over two cleaning contractors and a reception contractor is constructive and proportionate, could you tell me what would be disproportionate?
Senator, I think that's verging into the hypothetical. What I would say is that we don't commence any matter in the court without considering whether it's in the public interest. Now, you and I might have a difference of opinion on that, but we also seek prospects of success. And we would have sought prospects of success in this matter, and there would have been grounds for appeal. And so we don't take these matters lightly. We don't lose many cases, and when we do lose them, we always consider the question of whether they should be appealed, and we don't appeal every matter. Certainly there have been a couple of cases this year, test cases, where we made decisions not to appeal those matters. So I think that we are very responsible in weighing these issues, and that advice that we get about prospects must be independent legal advice, usually from a barrister. And so it's something that we put a lot of work and thought into. It's not a decision we take lightly. It is before the courts at the moment, and I don't really think it's appropriate for us to go into too much detail about those grounds of appeal, because they're the very matters that are before the court. When a decision comes down, we'd be happy to talk more about it with you in the estimates forum or offline if you'd like a briefing on how it was that we came to put that matter into court.
Are you able to provide an itemised list of costs of this litigation so far and what your estimate might be for the cost of running the appeal?
Senator, I'm sure we can provide some information about the costs. In terms of the estimation, I'll need to take that on notice, but we usually avoid second-guessing things, but given the hearings that have actually occurred, I would anticipate we wouldn't have too many more costs other than whatever we've already accrued.
I can confirm that.
Can you tell me about the awarding of costs in a matter like this?
Well, a matter like this, and most of the matters which we take forward, it's quite often referred to as a limited cost jurisdiction. That is to say that costs are not ordinarily awarded like they would be in other types of proceedings. So it's only in circumstances where, for example, litigation has been commenced and it's been found to have been vexatious, or there's been an unreasonable act or omission in the conduct of a matter, that costs will be awarded in favour of a particular party.
So this could end up costing Quest $1 million?
Well, I'm not in a position to comment in respect to that, Senator.
Should they win the appeal, then their cost to date plus the cost of defending the appeal could be $1 million.
Senator, I think Ms James has indicated that we're more than happy to provide you with a private briefing in respect of this matter. As she's indicated, and I have previously, the decision to appeal is not one that is taken lightly. We take our obligations very seriously, not only those under our own litigation policy, but also those contained in the legal services directions. And it was no different in this matter. We looked at those two issues, first the merits and secondly the public interest in proceeding. And on that basis, we've made the decision to appeal the proceedings which are currently reserved and before the full Federal Court of Australia.